Good afternoon. I am Kaushiki Roy, Assistant Professor at IIMT College of Law. Today I am going to deliver a lecture on the Constitution topic, and today's topic is Article 21 of the Constitution of India, right to life and personal liberty. Now let's just start with the introduction part. For introduction, Article 21 read as no person shall be deprived of his life or personal liberty except according to a procedure established by law. According to Justice Bhagwati, Article 21 embodies a constitutional value of supreme importance in a democratic society. Justice Iyer has categorized Article 21 as the procedural Magna Carta protective of life and liberty. This right has been held to be the heart of the Constitution, the most organic and progressive provision in our living Constitution, the foundation of our laws. Article 21 can only be claimed when a person is deprived of his life or personal liberty by the state as defined in Article 12. Violation of the right by private individuals is not within the purview of Article 21. Article 22 secures two rights basically. First right is right to life and the second one is right to personal liberty. The article prohibits the deprivation of the above rights except according to a procedure established by law. Article 21 corresponds to the Magna Carta of 1215, the Fifth Amendment to the American Constitution. Article 40, Clause 4 of the Constitution of I. 1937, Article of the Constitution of Japan. Article 21 applies to natural persons. The right is available to every person, citizen, or alien. Thus, even a foreigner can claim this right. It, however, does not entitle a foreigner the right to reside and settle in India, as mentioned in Article 19, Clause 1, Subclause E. Meaning and concept of right to life. Everyone has the right to life, liberty, and security of person. The right to life is undoubtedly the most fundamental of all rights. All other rights add quality to the life in question and depend on the pre-existence of life itself for their operation. As human rights can only attach to living beings, one might expect the right to life itself to be in some sense primarily, since none of the other rights would have any value or utility without it. Therefore, it would have been no fundamental rights worth mentioning if Article 21 has been interpreted in its original sense. This section will examine the right to life as interpreted and applied by the Supreme Court of India. Article 21 of the Constitution of India 1950 provides that no person shall be deprived of his life or personal liberty except according to procedures established by law. Life in Article 21 of the Constitution is not merely the physical act of breathing. Does not cannot mere animal existence or continued through life. It has a much wider meaning which includes right to live with human dignity, right to live livelihood, right to health, right to pollution free air, etc. Right to life is fundamental to our very existence. without which we cannot live as a human being, and includes all those aspects of life which go to make a man's life meaningful, complete, and worth living. It is the only article in the Constitution that has received the widest possible interpretation. Under the canopy of Article 21, so many rights have been found: shelter, growth, and nourishment. Thus, the bare necessities, minimum and basic requirements that are essential and unavoidable for a person is the core concept of the right to life. In the case of Kharak Singh versus State of Uttar Pradesh, the Supreme Court quoted and held that by the term life as here used something more is meant than more mere animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. The provision equally prohibits the mutilation of the body by amputation of an armed leg or the pulling out of an eye, or the destruction of any other organ of the body through which the soul communicates with the outer world. In Sunil Batra versus Delhi administration case, the Supreme Court reiterated with the approval the above observation and held that the right to life included the right to lead a healthy life so as to enjoy all functions of the human body in their prime conditions. It would even include the right to protection of a person's tradition, culture, heritage, and all that gives meaning to a man's life. It includes the right to live in peace, to sleep in peace, and the right to repose and health. Right to live with human dignity. In Menka Gandhi versus Union of India, the Supreme Court gave a new dimension to Article 21 and held that the right to live is not merely a physical right, but includes within its ambit the right to live with human dignity. Elaborating the same view, the court in Francis versus Union of Delhi observed that the right to live includes the right to live with human dignity and all that goes along with it. The bare necessities of life, such as adequate nutrition, clothing, shelter over the head, and facilities for reading, writing, and expressing oneself is diverse form, freely moving about and mixing and mingling with fellow human beings, and must include the right to basic necessities, the basic necessities of life, and also the right to carry on functions and activities as constitute the bare minimum expression of human self. Right against sexual harassment at workplace. Article 21 guarantees the right to life, right to life with dignity. The court in this context has observed that the meaning and content of fundamental rights guaranteed in the Constitution of India are of sufficient amplitude to encompass all facets of gender equality, including prevention of sexual harassment or abuse. Sexual harassment of women has been held by the Supreme Court to be violation of the most cherished of the fundamental rights, namely the right to life contained in Article 21. In Visakha versus State of Rajasthan, the Supreme Court had declared sexual harassment of a working woman at her work as amounting to the violation of rights of gender equality and rights to life and liberty, which is a clear violation of Article 14, 15, and 21 of the Constitution. In the landmark judgment, the Supreme Court, in the absence of enacted law to provide for effective enforcement of basic human rights of gender equality and guarantee against the sexual harassment, laid down the following guidelines. All employers or persons in charge of workplace, whether in the public or private sector, should take appropriate steps to prevent sexual harassment without prejudice to the general of this obligation. They should take the following steps. First is express prohibition of sexual harassment as defined above. All the workplace should be notified, published and circulated in appropriate ways. Second one is the rules, regulations of government and public sector bodies relating to conduct and discipline should include rules, regulation prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. Right to livelihood. To begin with, the Supreme Court took the view that the right to life in Article 21 would not include the right to livelihood. A case which arose before Menka Gandhi case, where the Supreme Court ruled that the right to livelihood not fall within the expression life in 21. The court said the right to livelihood would be included in the freedoms enumerated in Article 19 or even in Article 16 in a limited sense. But the language of Article 21 cannot be pressed into aid of the argument that the word life in Article 21 includes livelihood also. Right to social security and protection of family. Right to life covers within its ambit the right to social security and protection of family. Justice Ramaswamy in Calcutta Electricity Supply Corporation Limited versus Subhash Chandra Bose held that the right to social and economic justice is a fundamental right under the Article 21. The learned judge explained that the right to life and dignity of a person and status without means were cosmetic rights. Socio-economic rights were therefore basic aspirations for meaning the right to life and that right to social security and protection of family were an integral part of the right to life. In NHRC versus State of Arunachal Pradesh, the Supreme Court said that the state is bound to protect the life and liberty of every human being. He is a citizen or otherwise, and it cannot permit anybody to or group a person to threaten other person or group of persons. No state government worth the name can tolerate such threats by one group of person to another group of persons. It is a duty bound to protect the threatened group from such assaults, and if it fails to do so, it will fail to perform its constitutional as well as statutory obligations. Right against honor killing. A division bench of Allahabad High Court in Surjit Kumar versus State of UP took serious note on harassment, ill treatment, and killing of a person who was a major for wanting to get married to a person of another caste or community, for bringing dishonor to family, since intercaste or intercommunity marriage was not prohibited in law. The court said that such practice of honor killing was a blot on society. The court therefore directed the police to take strong measures against those who committed such honor killing. Right to health. In State versus MS Chawla, it has been held that the right to life guaranteed under Article 21 includes within its ambit the right to health and medical care. The Supreme Court in Vincent versus Union of India emphasized that a healthy body is the very foundation of all human activities. Article 47 Directive Principle of State Policy in this regard lays stress note on the improvement of public health and prohibition of drugs injurious to health as one of the prior duties of the state. No right to die. Article 21 confers on a person the right to live a dignified life. Does it also confers a right not to live or a right to die if a person chooses to end his life? If so, what is the fate of Section 309 IPC 1860, which punishes a person convicted of attempting to commit suicide? There has been a difference of opinion on the justification of this provision to continue on the statute book. This question came for consideration for the first time before the High Court of Bombay in the state of Madras, Maharashtra versus Maruti Shripati Dubbal. In this case, the Bombay High Court held that the right to life guaranteed under Article 21 includes right to die, and the Honorable High Court struck down Section 309 of the IPC that provides punishment for an attempt to commit suicide by a person as unconditional. In P. Rathinam versus Union of India, a two-judge division bench of the Supreme Court took cognizance of the relationship contradiction between Section 309 IPC and Article 21. The court supported the decision of the High Court, also embodied in it a right not to live a forced life to his detriment, disadvantage, or disliking. Euthanasia and right to life. Euthanasia is termi- termination of the life of a person who is terminally ill or in a permanent vegetative state. In Gyan Kaur versus State of Punjab, the Supreme Court has distinguished between euthanasia and attempt to commit suicide. The court held that death due to determination of natural life is certain and imminent, and the process of natural death has commenced. These are not cases of extinguishing life, but only of accelerating conclusion of the process of natural death, death has already commenced. The court further held that this may fall within the ambit of right to life with human dignity up to the end of natural life. This may include the right of dying man to also die with dignity with his life is ebbing out. This cannot be equated with the right to die and unnatural death, curtailing the natural span of life. Right to get pollution free water and air. The preamble of the Constitution of India is well drafted the document which states the philosophy of the Constitution. It declares India to be a sovereign, socialist, secular, democratic republic and a welfare state committed to secure justice, liberty, and equality for the people for promoting fraternity, dignity, and individual, and unity and integrity of the nation. The preamble is the key to the constitution. It states a nutshell the nature of Indian state and the objectives it is committed to secure for the people. In Subhas Kumar versus State of Bihar, it was held that a public interest litigation is maintainable for ensuring enjoyment of pollution free water and air, which is included in right to life under Article 21 of the Constitution. The court observed right to life is a fundamental right under Article 21 of the Constitution and it includes the right of enjoyment of pollution free water and air for full enjoyment of life. If anything endangers or impairs that quality of life in derogation of laws, a citizen has right to have recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to the quality of life. Right to clean environment. The right to life under Article 21 means a life of dignity to live in a proper environment free from dangers of disease and infection. Maintenance of health, preservation of the sanitation and environment have been held to fall within the purview of Article 21 as it adversely affects the life of the citizens and it amounts to slow poisoning and reducing the life of the citizens because of the hazards created if not checked. The following are some of the well-known cases on environment under Article 21. In MC Mehta versus Union of India 1988, the Supreme Court ordered the closure of tanneries that were polluting water. The right to know or right to be informed. India gives a special status to no religion. There is no such thing as a state religion of India. This makes it different from theocratic states like the Islamic Republic of Pakistan or other Islamic countries. Further, Indian secularism holding that the right to life has reached new dimensions and urgency. The Supreme Court in RP Limited versus Proprietors India Express newspaper, Bombay Private Limited, observed that if democracy has to function effectively, people must have the right to know and to obtain the conduct of affairs of the state. In Isar Oil Limited versus Halar Utkarsh Samiti, the Supreme Court said that there was a strong link between Article 21 and right to know, particularly where secret government decisions may affect health, life, and livelihood. Peace equals freedom to all religions. The Constitution grants the right to religious freedom to all the citizens. Personal liberties. The Constitution of India provides for a democratic system. The authority of liberty of the person is one of the oldest concepts to be protected by national courts. As long as the English Magna Carta provides that the smallest article of 18 word has the greatest significance for those who cherish the ideas of liberty. What can be more important than liberty? In India, the concept of liberty has received a far more expansive interpretation. The Supreme Court of India has rejected the view that liberty denotes merely freedom from bodily restraint and has held that it encompasses those rights and privileges that have long been recognized as being essential to the orderly pursuit of happiness by free men. If the government rests upon the sovereignty of the people enjoy equal political rights. On the basis of these rights, the people freely participated in the process of politics. They elect their government. Free, fair, and regular elections are held for electing governments. For all its activities, the government of India is responsible before the people. The people can change their government through elections. No government can remain in power which does not enjoy the confidence of the people. India is world's largest working democracy. Right to privacy. The preamble declares India to be a republic. India is not ruled by a monarch or nominated head of state. India has an elected head of state, President of India, who wields powers for a fixed term of 5 years. After every 5 years, the person of India indirectly elect their president. For the first time in Kharak Singh versus State of Uttar Pradesh, question whether the right to privacy could be amplified from the extinguishing fundamental rights such as Article 19, Clause 1D, 19, Clause 1E, and 21 came before the court. Surveillance under Chapter 20 of the UP Police Regulations constituted an infringement of any of the fundamental rights guaranteed by Part 3 of the Constitution. Regulation which permitted surveillance by visits at night was held to be in violation of Article 21. A seven-judge bench held that the meaning of the expression life and personal liberty in Article 21 were considered by this court in Kharak Singh's case, although the majority found that the Constitution contained no explicit guarantee of a right to privacy. It read the right to personal liberty expansively to include a right to dignity. It held that an unauthorized intrusion into a person's home and the disturbance caused to him hereby is as where the violation of a common law right of a man and ultimate essential of ordered liberty, if not of the very concept of civilization. Scope and content of right to privacy. Tapping of telephone. Emanating from the right to privacy is the question of tapping of the telephone. In R.M. Malkani versus State of Maharashtra, the Supreme Court held that the telephonic conversation of an innocent citizen will be protected by court against wrongful or high-handed interference by tapping the conversation. The protection is not for the guilty citizen against the efforts of the police to vindicate the law and prevent corruption of public servants. So this session ends today. I hope you all will like this. Okay. Thank you so much. Thank you.